Now I am going to dictate a legal passage based on latest judgment of the Supreme Court at the rate of 120 words per minute. Let's start. In the case of Gayatri Balasamy versus Mrs. ISG Novasoft Technologies Limited, decided on April 30, 2025, the Supreme Court of India addressed a long-standing legal question whether Indian courts possess the jurisdiction to modify arbitral awards under Section 34 and 37 of the Arbitration and Conciliation Act 1996. This judgment delivered by a five-judge constitutional bench led by Chief Justice Sanjeev Khanna marked a significant development in Indian arbitration jurisprudence, clarifying the scope of judicial intervention in arbitral proceedings. The dispute originated from a workplace conflict involving Ms. Gayatri Balasamy, who served as Vice President in the M&A Integration Strategy Department of ISG Novasoft Technologies Limited in 2006. She tendered her resignation citing sexual harassment by the company's CEO. The resignation was not accepted and she was subsequently issued 3 termination letters over the course of a year. Ms. Balasamy filed criminal complaints under the Indian Penal Code and the Tamil Nadu Prohibition of Harassment of Women Act. In retaliation, the company filed counter complaints alleging defamation and extortion. Eventually, both parties agreed to resolve the matter through arbitration. The arbitral tribunal awarded Ms. Balasamy rupees 2 crore in compensation. Dissatisfied with the award, she approached the Madras High Court under Section 34 of the Arbitration Act seeking modification. A single judge bench enhanced the award by rupees 1.6 crore citing overlooked claims. However, a division bench later reduced this enhancement to 50,000, terming the additional compensation excessive and lacking arithmetic logic. Agreed, Ms. Balasamy filed a special leave petition before the Supreme Court. The central legal issue before the Apex Court was whether the powers conferred under Section 34 and 37 of the Arbitration and Conciliation Act include the authority to modify an arbitral award. Traditionally, Section 34 allows courts to set aside an award on limited grounds such as incapacity, invalid arbitration agreement, or procedural irregularities. Section 37 permits appeals against orders passed under Section 34. However, neither provision explicitly mentions modification. The Supreme Court acknowledged the judicial divergence on this issue in earlier cases such as Project Director NHAL versus M. Hakim. The court held that modification was not permissible, emphasizing minimal judicial interference. Conversely, in cases like Vedanto Limited versus Shenzhen Shandong Nuclear Power Construction Company, the court has modified interest rates and other components of arbitral awards. This inconsistency necessitated a definitive ruling. The majority opinion authority by Chief Justice Khanna and supported by Justice Gavi Sanjay Kumar and Mahesh held that courts do possess a limited power to modify arbitral awards provided certain conditions are met. The court invoked the Latin maxim omne majus continent in se minus. The greater power includes the latest to argue that the power to set aside an award inherently includes the power to partially set it aside or modify it. The judgment laid down clear parameters for permissible modification. First, the award must be severable, meaning the invalid portion can be surgically removed without affecting the valid part. Second, courts may correct clerical, computational, or typographical errors that are apparent on the face of the record. Third, courts may alter post-award interest if circumstances justify such intervention. Fourth, in rare cases, courts may invoke Article 142 of the Constitution to do complete justice. However, the court cautioned against using modification as a tool for merit-based evaluation, which would amount to judicial overreach. The power to modify must be exercised with restraint and only when the error is manifest and indisputable. If the modification requires a reappreciation of evidence or factual inquiry, the court must refrain and instead set aside the award or remand the matter. Para. Justice K. V. Viswanathan authored a dissenting opinion arguing that the Arbitration Act does not permit modification. He emphasized that the legislature deliberately excluded such power to preserve the finality and autonomy of arbitral awards. According to him, allowing modification would blur the line between judicial review and appellate jurisdiction, undermining the very purpose of arbitration. Para. The judgment also examined international practice, nothing that jurisdictions like Singapore, the UK and Australia allow limited modification under specific circumstances. However, the ancestral model law on which the Indian Arbitration Act is based does not contemplate modification. The court acknowledged this but held that Indian constitutional principles and judicial precedents justify a nuanced approach. Para. The ruling has far-reaching implications. It provides clarity to lower courts and arbitration practitioners, enabling them to navigate post-award proceedings with greater confidence. It also reduces the likelihood of re-arbitration, saving time and resources. However, the judgment leaves certain aspects open-ended, such as the definition of manifest error and the practical challenges of severability in consolidated awards. Para. Legal scholars have welcomed the judgment as a progressive step, balancing efficiency with fairness. It empowers courts to correct obvious mistakes without reopening the entire arbitration. At the same time, it preserves the sanctity of arbitral autonomy by restricting modification to exceptional cases. Para. In conclusion, Gayatri Balasubramanian versus ISG Nova Soft Technologies Limited is a landmark decision that settles a contentious issue in Indian arbitration law. By recognizing a limited power of modification, the Supreme Court has reinforced the judiciary's role as a guardian of justice while respecting the principles of party autonomy and minimal intervention for legal aspirants and practitioners alike. This case serves as a vital reference point in understanding. Stop. Thank you.